Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. The next subject discussed in the California Bar Exam Essay Guide is constitutional law. This subject appears on both the multiple choice and essay portions of the bar exam. Let's talk about how constitutional law is tested on the essay portion of the bar exam. Constitutional law shows up about once every 2 to 3 administrations of the bar exam. It is usually tested on its own, but sometimes appears as a crossover question. We've seen it tested as a crossover with real property, where the issue was eminent domain or takings under the Due Process Clause. When constitutional law is tested, the question simply tests the U.S. Constitution, so you can apply the same law that you learned for the multiple choice portion on the essay portion. There are no California distinctions to be aware of here. Next, I want to talk about the issues that have appeared frequently on constitutional law essays. The first is an issue that you should mention on every single constitutional law essay answer, even if it isn't a major issue. That is standing. In order to have standing, the plaintiff must show an injury in fact, causation, and redressability. When this is an issue in the essay and there are actually facts to discuss it, the examiners actually like to test organizational standing. An organization can sue for an injury to itself and can also sue for injuries to its members if a member or members have standing, the member's injury is related to the purpose of the association, and the individual members are not required to participate in the lawsuit. This issue came up on the July 2019 exam. In the constitutional law essay, a city passed an ordinance banning candle burning in churches. A church sued on behalf of its members to challenge the constitutionality of the ordinance. Here, the members' alleged injury is that they are prohibited from freely practicing their religion. This is related to their membership in the association, and there is no reason why the individual members of the church must participate in the lawsuit. So the church has organizational standing to sue on behalf of its members. The next issue that is frequently tested on constitutional law essays is the Dormant Commerce Clause. The Dormant Commerce Clause provides states may not discriminate against interstate commerce or unreasonably burden interstate commerce. Laws that discriminate against interstate commerce are struck down unless they can pass strict scrutiny. A law that burdens interstate commerce but does not discriminate on its face will be upheld if it serves an important state interest and does not impose an unreasonable burden on interstate commerce. To do this analysis, you would use a balancing test, weighing the state's interest against the burden imposed on interstate commerce. I'll give you an example to show you how the balancing test works. The Bibb versus Navajo Freight Lines case involved an Illinois law which required all trucks to have curved mud guards. The court held that this law placed an unreasonable burden on interstate commerce because the benefit the state received was minimal compared to the burden that this ordinance placed on interstate commerce. It doesn't really matter to the state what shape the mud guards are, and trucks would have to get new mud guards, or certain trucks could not pass through Illinois without paying a fine, which would be a fairly significant burden. Thus, the law requiring curved mud guards was an unconstitutional violation of the Dormant Commerce Clause. The third highly tested constitutional law issue is due process and equal protection and the standards of scrutiny under each. There are 3 levels of scrutiny that government action could face: strict scrutiny, intermediate scrutiny, and rational basis. When strict scrutiny applies, the government has the burden and must show a compelling interest and that the law is narrowly tailored to achieve that interest. Under intermediate scrutiny, the government bears the burden and must prove that the challenged law is substantially related to an important government interest. Finally, under rational basis, the plaintiff bears the burden of showing that the law is not rationally related to any legitimate purpose. You should memorize the standards and also the situations to which each standard applies. For example, under the Equal Protection Clause, strict scrutiny applies to fundamental rights, alienage, and racial or ethnic discrimination. A really helpful tip here is to remember that under a strict scrutiny analysis, the government usually loses because this is a really hard standard for the government to meet. And under rational basis, the government usually wins because it's hard for the challenger to show that the government does not have any legitimate interest with respect to the challenged law. If you remember this, you'll have a much easier time reaching a conclusion on these issues because you will know what the outcome should be. The fourth issue that we're going to talk about that frequently appears on California constitutional law essays is free speech. There are a lot of different sub-issues that have come up on the essays from the topic of free speech, but several of the examiner's favorites include time, place, and manner restrictions and general free speech principles such as vagueness and overbreadth. With regard to time, place, and manner restrictions, the rule is that the government can place reasonable regulations on the time, place, and/or manner of speech. Think about those words, time, place, and manner, carefully. The government can regulate how speech is conveyed. They cannot, however, regulate what speech is conveyed. If the area in which the government is regulating speech is a traditional or designated public forum, like a park or a school that is open to the public after school hours, then the regulation must be content neutral, narrowly tailored to an important government interest, and allow alternative channels of communication. So let's say that a city passes an ordinance that prohibits all public gatherings in the park between the hours of 8 p.m. and 8 a.m. because they've received several noise complaints from nearby homeowners, so they want to limit the amount of noise late at night. This ordinance would likely be upheld. The regulation is content neutral because it prohibits all public gatherings, not just gatherings for a specific topic or purpose. Also, the city has an important interest, reducing noise pollution. And the law is narrowly tailored because it only restricts public gatherings for a few hours during the night. There are alternative channels because people could gather during the day. I'll give you a different example. Let's say that a city wants to reduce litter, so they ban handing out leaflets. A complete ban will not usually be upheld because it is not usually considered narrowly tailored. There are other ways of reducing litter, such as putting out additional trash cans or requiring people handing out leaflets to pick up the litter afterwards. Other speech issues that have come up on the California essays include speech in non-public forums, such as government workplaces or student speech in school. Make sure you review the entire First Amendment free speech doctrine so that you're familiar with the other types of speech issues that could be tested. The final issue we're going to talk about is freedom of religion. There are two clauses of the First Amendment protecting freedom of religion, the Establishment Clause and the Free Exercise Clause. The Establishment Clause prohibits the government from favoring one religion over another or favoring religion over non-religion. Laws that expressly favor religion are subject to strict scrutiny. In 2022, the Supreme Court issued an opinion in the case Kennedy v. Bremerton School District that abolished the three-part Lemon test, which was previously used to determine whether a law which was neutral on its face violated the Establishment Clause. Now, when analyzing a neutral law, the court will interpret the Establishment Clause according to reference to historical practices and understandings. It's important to keep in mind that the Lemon test is no longer good law, so as you're looking at older constitutional law essays that tested the Establishment Clause, if you see sample answers discussing the Lemon test, you should not learn that version of the law as it is no longer applicable. The Free Exercise Clause applies when the government is attempting to regulate individuals' ability to practice their religion. Under the Free Exercise Clause, a state may only regulate or prohibit conduct if the regulation is neutral and of general applicability. In other words, the government cannot target conduct simply because it is religious in nature. The third tip for constitutional law essays is to be aware of how to approach certain highly tested topics in your answer. For instance, I mentioned that you should almost always address standing in your answer, even if you don't have a lot of facts that make it a significant issue. Furthermore, when you discuss standing, you should start with the general rule and discuss injury in fact, causation, and redressability before moving into any more specific standing issues, such as organizational standing or taxpayer standing. You also usually need to mention that there has been government action that is being challenged in a constitutional law essay answer. The constitutional protections only apply to the government, so there must be state action in order to bring a constitutional challenge. Finally, you should always state the general rule before moving into more specific issues or exceptions. For example, if free speech is tested, start by identifying the language of the First Amendment and things like the difference between content-neutral and content-based regulations before you dive into the specific test that is applicable to the facts. Practicing constitutional law essays will help you see the way that the examiners expect you to discuss these various issues and will also expose you to the types of issues that could appear on a constitutional law essay question. The examiners tend to test similar issues over and over on constitutional law essays, so practicing will help ensure that you're exposed to and prepared for as many of these common issues as possible. We suggest that you start by reviewing the constitutional law essays from July 2019, July 2018, February 2018, July 2016, and July 2015.